Okay, we'll move on to Friends of Ravenna, Cowan, and Carey versus Seattle. And also consolidated for argument, we're consolidating the argument with Godfrey versus Hearing Examiner. Okay, so the way we'd like to handle this argument is Friends of Ravenna and Carey get 10 minutes, and Godfrey gets 10 minutes. You may reserve rebuttal time from that. Then the city will have 20 minutes, and then we will hear any reserved rebuttal argument. So with that, we'll start with Friends of Ravenna, Cowan.
Thank you, Your Honor, and we would reserve 3 minutes, please, for rebuttal.
You got it.
Good morning, Your Honors, and may it please the Court. My name is Chris Schouts, and I represent the Friends of Ravenna, Cowan, and John Carey. This case concerns a review process that SEPA and Seattle's own code expressly allow. Review by a hearing examiner of the adequacy of a final EIS, Environmental Impact Statement, for the city's comprehensive 20-year growth plan before the City Council makes legislative decisions based on that study. However, the examiner dismissed those appeals. He ruled, first of all, they were barred by what we called the appeal prohibition statutes, which prohibit certain appeals based on their housing intent. And second, as to Mr. Carey, that he could not appeal because he did not submit written comments on the draft EIS. The Superior Court then denied a writ of review, and that order is what we are challenging here.
So we're here reviewing the writ of review, the denial of the writ of review.
Correct, Your Honor. I think that's a very important point. We're not here to examine the merits of the FEIS. We're not here to judge anything else other than the fact that did the examiner make the right decision in refusing to allow the appeals to go forward.
So it's basically a jurisdictional, I mean, it's like a jurisdictional question.
Yes, Your Honor, jurisdictional or procedural. However you look at it, it's just simply we have this right to have taken these appeals. They were dismissed by a statute that simply doesn't apply.
I just want to confirm that if the hearing examiner had heard the appeals, you agree there would be no writ available on that. If they'd heard the appeals and denied them, you agree there would be no.
Yeah, actually what would happen, Your Honor, is if the examiner heard the merits of the appeal and he affirmed that what the statute provides is he affirms the environmental statement is correct, then that's it. That's the end of the game. There is no further appeal. We could not seek a writ. That's the end of it.
I mean, the remedy would have been to go to the Growth Management Hearings Board, but for the statute.
Pardon?
The remedy would have been to go to the Growth Management Hearings Board at that point,
But for the appeal. Well, while we're appealing to the city examiner, we can't go to the Growth Management Hearing Board because we can't appeal anything to the Growth Hearing Management Board unless there is first an enactment of legislation. So be that a question about the FEIS itself, the adequacy of the statement, or the examiner's own decision. The Growth Management Hearing Board considers only ordinances, statutes, and so on that are passed regarding the growth management plan. It does not examine what hearing examiners look at. It does not, do any of that. And it does not, like we can do with the hearing examiner, look at what we've called orphan EISs, an examination of an EIS itself. So And I think we've already started on one of the central points of the writ was, is there a plain, speedy, and adequate remedy to review the examiner's order other than seeking a writ and having the court pass judgment on it? And the answer is no. The answer from the city was it's the Growth Management Hearing Board. But I think as we've pretty well covered, it can't do that. It can't touch the EIS. It can't touch the hearing examiner. And they say, well, that's okay. Never mind. You'll just have to sit around and wait till something's enacted. And I think as we talk about in our briefing, that totally changes the context of what is happening and takes away the purpose of this statute that we've appealed under, which allows an early appeal before legislation is enacted. And I think, like I said in the brief, it's more informational. It's, can we find out really, do these statements support what they're seeking, particularly when it comes time to the specifics of zoning and so on. And we can do that while consultation's going on as part of the input process. Contrary to what the city says, that does not impede the legislation, it assists it.
I want to jump ahead a little bit because I'm struggling a little bit with where this goes. So let's assume, for the sake of argument, that we agree with you that the hearing examiner did have jurisdiction to hear these appeals. If the hearing examiner hears them and says the FEIS is adequate, it affirms the FEIS, you're done.
That's it.
If the hearing examiner says, no, do a supplemental EIS, and the city does, and the city council ignores that, you're done.
If the city, well, if they ignore an order, and it wouldn't be the city
No,
council.
I'm saying if the city council ignores what's done in the supplemental environmental impact statement, for example, there's no appeal of that. It's a legal it's a decision. They're making a policy decision, adopting the plan.
Right. So, I guess what happens if it's really then a directive to the planning department to issue the new.
Sure, and if they do it, the city council can still act.
Right, and the city council can look at that and say, okay, this is new information, or we can use it as people who are trying to make arguments and say, see what this shows. And if the city just says, well, okay, we got it, but we're still going to go ahead and pass the legislation. That's it. Now, then the question is, well, what if we're dissatisfied with that whole process? Can we appeal to the Growth Management Hearing Board? And the answer would be yes, but we would now be clearly facing the appeal document.
Any appeal would be very
because there's an
limited.
enacted statute, so they'd quickly be barred by that. My time's running off quickly, so I want to put a quick pitch in for Mr. Carey, whose petition was dismissed. I'll come back. Thank you very much, Your Honor.
Thank you.
Good morning. May it please the court. My name is Toby Thaler. I represent Jennifer Godfrey in the other appeal of the city's EIS. Before I start on my main points, I'm not in a total agreement that there might not be an appeal on the writ to the Superior Court after the completion of the process and the City Council acts.
Well, let's start there. Do you agree that we're here basically to review the hearing examiner's, I'll just call it jurisdictional decision that he could not hear an appeal?
Yes, I agree with that. We
That was
agree.
the purpose of the writ.
Yes.
Okay.
To provide a plain and adequate, speedy and adequate remedy, judicial remedy for alleged deficiencies of the SEPA review.
Okay, so if the hearing examiner then had heard the appeal and affirmed the EIS, there would be no further appeal from that decision, correct?
Well, that's where I'm not sure. Under the Growth Management Act, GMA failures have to go to the Growth Management Hearings Board.
Right.
I hadn't thought about the question of the SEPA issues, so I'm saying I'm not in total agreement unless I have a chance to look at that. This is a case of first impression on the quasi-judicial internal review before the city council has to act on the proposals from the executive side of the city. These appeals have been provided since 1983. In the original SEPA statute, this exact process was provided for. It was included in the WACs in 84 and included in the city's municipal code in 84 as well. And there have been numerous appeals to the hearing examiner since that time on the adequacy of SEPA review by administrative departments at the city. The city has acknowledged the existence of those appeals in the record. If you look at Clerk's Paper 44 and 45, it very explicitly says if you don't like what the department, OPCD, Office of Planning and Community Development, did, take it to the hearing examiner, and here's how you do it. Actually laid it out. You have.
What the hearing examiner has done is, you agree the legislature's essentially gone out of its way to foreclose appeals of these planning decisions and the environmental review for these planning.
Only after they have become an ordinance. The city acknowledged, as I said, that the existence of this, and if you look at the statute, there is a number of them, and they say ordinance, action. There is no action and there's no ordinance until the city council acts.
But the hearing examiner, as I read the opinion, reaches the conclusion that for me to hear this appeal would contradict the rest of the legislative actions that have taken away subsequent appeals.
I'm sorry?
I mean, as I read the hearing examiner's decision, he's saying to read the statute to allow the interim appeal at the city level would basically be ridiculous because we know it can't go any further.
Well, that's where I'm not sure whether a writ lies, because a writ should lie here where the hearing examiner rejected it. Why would a writ not lie if the hearing examiner goes through the evidence? Is there no opportunity to have the hearing examiner's decision on the merits reviewed?
Sure. It can go to the Growth Management Hearings Board. And you
And
lose.
that's at least-
And you lose because
that-
the statute has taken that away.
Godfrey does not lose because her issues are explicitly focused on fish habitat. So the prohibition statutes do not apply to Godfrey's case.
By that argument, you would not be entitled to a writ because now you have
The alternative, correct. We have an adequate remedy for at least those issues. When I say I'm equivocating on the non-fish issues. Housing, for example. Godfrey's citywide appeal and 5 other appeals were filed in early February of '25. The hearing examiner did a pre-hearing order and received motions to dismiss all the appeals.
Let me ask you this. We now know the city has adopted the plan and has adopted phase 1 of the development regulations, has not yet adopted phase 2. And I want to talk specifically about Godfrey. What is left of Godfrey's appeal on the phase 2?
The crucial piece of this is that the city uses this EIS to inform all its future decisions concerning land use planning of any significance that would otherwise require a threshold determination, they bootstrap it to this EIS. There are already 2 other ordinances adopted, and they, in the whereases, say this FEIS has been prepared. Therefore, we don't have to do any more SEPA. That's phased review, and the city uses that process without explicitly saying it's phased review, just relies on that EIS, and nobody ever gets a chance to appeal those again until the next round in 10 years. That also speaks to the mootness question. The case is not moot because the city will continue churning out major actions that do citywide or area-wide changes that have environmental impacts, but no SEPA review because this EIS is good enough. And I have 7 seconds. Thank you.
Thank you.
Sorry, I'm a little taller. All right. Good morning. May it please the court. My name is Max Burke. I represent the respondent, City of Seattle. So I want to set aside the outstanding motions and just talk about the merits. A writ of review is an extraordinary remedy to be granted sparingly. There are 2 independent reasons for denying the writs here. One, there's an adequate legal remedy for appellants.
Let's talk about that.
Yes.
Do you agree essentially the hearing examiner made a jurisdictional determination that he could not hear these appeals?
Yes.
So that's a yes or no, I cannot hear them. Even the city code allows for these appeals, correct?
That is where I would
The city
disagree.
code does allow for an appeal of an FEIS prior to the non-project action.
In general, Your Honor, yes. However, there is a code provision, and we didn't unfortunately highlight it in our briefing, but there is a code provision that expressly cites these statutes and says that an appeal, it's SMC 2505-680 subsection F, and I can read it to you. It says RCW 3670A-070, 3670A-600, which is that issue here, and 4321C-495, which is that issue here, exempts certain council land use decisions from administrative or judicial appeals except as provided in a certain code section. And then it does say, environmental documents and council land use decisions, actions intended to be exempt from SEPA appeals pursuant to this should so state. I'm not sure if that happened here, but it does reference these, the code.
Should what?
It should so state, so the document should reference those statutes.
I listened to what you just read. You mentioned you didn't highlight it in your brief. Did you cite it in your
Yeah,
brief?
we did.
Okay,
We did.
all right.
We didn't rely heavily on it because state law, if there's a conflict, state law governs here. So even if the code would allow these appeals, our argument is that state law does
Well,
not.
I mean,
didn't-
oh, go ahead. I'm sorry. Go ahead.
It didn't sound to me like what you just read said, kind of point blank, and the city code does not provide for appeals of subject matters falling within these statutes. I didn't hear that part,
Yeah, it doesn't say it as expressly as that.
okay? Because it doesn't seem, I mean, it's optional for the city to allow this level of appeal at all,
Correct.
right? So you would be, it seems like if the city code doesn't take this appeal off the table expressly, your argument, I agree with you, state law controls, but we would need to find in the appeal prohibition statutes further legislative intent that this optional level of appeal also be refused to municipalities. In other words, the legislature not only said there can't be an appeal to the board, we would have to infer, we would have to find legislative intent that a municipality couldn't either have an internal appeal at its own option.
Yeah, so
And the legislature did not amend, I mean, 4321C075 and his 3B little 3 sets up this optional appeal for the city to hear an FEIS appeal on a non-project action like this. And that was not amended.
I'm
The
sorry.
legislature did not amend 4321C075, the statutory provision that
Correct.
provides the city the ability to have this appeal, this interim appeal. That was not amended by the legislature.
That was not amended. However, I think it's clear from the express legislative intent of the act and the surrounding statutory provisions that they intended to bar all SEPA appeals, whether
The
pre-decision or
legislature
not.
knows how to amend a statute, right? I mean, they could
Correct.
have amended that provision of the statute if they'd intended to.
Yeah, and I will admit that the statute is not a model of clarity, but it's not it's not ambiguous. That what the intent of the statutes is to prevent these exact type of SEPA appeals and instead promote housing construction.
But what if the intent of the statute is to make sure that the city council at least has good information in front of it internally before it makes a decision? And then from then on, no more appeals. But if I read this, it looks like the legislature's left in place the ability to make sure the city council has the right information before it acts.
I would respectfully disagree and say the legislature gave no indication that they intended to keep these types of appeals
Well, they
for
didn't
housing
take it
loans.
out. They didn't take it off the table.
I think that I respectfully disagree, and I think that this statute takes it off the table. And I can explain.
Let me turn to this, where you started your argument. The hearing examiner determines he does not have jurisdiction, I'll just use jurisdiction loosely.
Sure.
To hear these appeals. Where can that decision be appealed?
That decision has no appeal.
So isn't that the purpose of a writ of review? There is no adequate remedy other than it
But
being a writ.
Your Honor, you nailed it on the head in the question you had for the appellants, which is there wouldn't be an appeal if the examiner took the case, heard it on the merits, and then ruled in favor of the city.
Correct.
There would be no appeal there either.
Correct.
But there can't be a writ because of that.
Well, but the city code, again, the statute allows this process. I'm just looking at where that procedural determination, a jurisdictional determination, where can that be? Who decides whether the hearing examiner made a correct call on that?
The legislature set up the CPO appeal process where it doesn't allow for an appeal for that.
I mean, you've kind of pivoted from what I think we're driving at here. There's a difference between a writ of review saying, this agency in this internal appeal got the decision wrong, and, the agency's code says there's no appeal from that decision. There's a difference between appealing the merits of the decision, if there is a merits decision, versus seeking a writ and saying, hey, this agency didn't follow its own procedure. That's the distinction we're driving at here. That, the failure of an agency to follow its own procedure is essentially a different kind of wrong than the agency making an incorrect decision.
I don't think that that's the logic of appellants' arguments. Their argument is that they have no direct appeal, and they do not want to wait for the legislation to get passed to make their claims to the Growth Management Hearings Board. So they deserve to use a writ to come to court.
Well, what about the logic of my question, whether you agree they make that argument or not? I guess I'm asking, which is, if the city, by statute can, and by code has, afforded an internal appeal before the council has made a decision on whether to pass an ordinance, and the city just doesn't afford that procedure, isn't that a wrong that can be asserted distinct from whether they've correctly evaluated the FEIS?
I would agree with that hypothetical, but I don't think that's what's happened here.
Okay.
I think the statutes, meaning the appeal prohibition statutes, do not allow this type of appeal, and our code references those statutes and says there are no exempts certain council land use actions from administrative or judicial appeals. There wouldn't be a reason to show that in our code if it didn't apply to the hearing examiner appeal.
I mean, I think I would agree with you that if we thought the appeal prohibition statutes also took off the table a municipality's option to afford an internal review, then, I think we could probably cut to the chase on this case. If we don't agree with you, I'm not sure it's that simple.
Yeah, I think the statutes, while not a model of clarity, are unambiguous that they intended to prevent all SEPA appeals, whether pre-decision or not. And I'd like to explain why I think that, if I may. So, that intent is evident from express legislative intent. The title of the act adopting the operative language in 3 of the statutes states, in relevant part, an act relating to promoting housing construction in cities through ... limiting appeals under the State Environmental Policy Act and Growth Management Act.
Terrible word for you, because it doesn't say eliminating.
Yes, it does have, so one of those statutes is 070, which has the fish habitat exception, which is not at issue in this case, despite what my colleague...
I mean, I kept looking for, I kept waiting for your brief to get to the legislative history that was going to say, a bill report or testimony to say, we got a housing crisis, we got to, stop this, stop these endless appeals. I didn't see it in your brief.
Yeah, unfortunately, there is not a lot of legislative history on this. However, there is testimony from the public about this, but we did not feel that needed to be included in our briefing.
Can I move you ahead for a little bit? 'Cause
Sure.
I want to talk about mootness, because you also have brought a motion to dismiss as moot. And I recognize the one Seattle plan's been adopted, and phase 1 of the development regulations has been adopted. In your argument, it actually came up in your reply, you say that there's nothing left for phase 2 because we've already adopted the one Seattle plan, and so it has to be consistent. And what I'm bothered by is it's footnote 3. You cite one Seattle plan policy GS 6.3.
Yes.
And your statement is allow moderate scale housing of 4 to 6 units ... along arterials near frequent transit.
Yes.
What concerns me is that ...
And why is that?
Because the ... says where zoned densities may be increased to provide more housing. Maybe.
Yeah.
So if the city council decides in phase 2 not to adopt phase 2,
They can do that.
that would be consistent with the comprehensive plan.
Yes.
And so if the city council decides to adopt phase 2, that would be consistent with the comprehensive plan.
Correct.
So the city council still has discretion to either approve phase 2 or not, and it would still be consistent with the comprehensive plan.
Agreed. I'm not...
In that case, it's not moot. The issues under phase 2 are not moot.
The environmental analysis is moot, though. The environmental analysis analyzed, assuming that...
We're not going to answer that, because that's not our job, to look at the environmental analysis and decide whether or not to analyze it. That was the hearing examiner's job.
That's the very hearing that didn't happen, right?
Correct.
So if
It's moot,
if
but-
that hearing's never happened,
Their
how
claims...
could the question of whether there should be a hearing be moot?
Say that again, I'm sorry.
The hearing never happened. If the question today is should there have been a hearing, and that hearing would evaluate the adequacy of the environmental impact statement on which the city will then proceed to decide whether to implement phase 2, how could this case be moot?
So let's hypothetically say that the court remands it to the examiner, and the examiner is analyzing the FEIS and the adequacy of the analysis. That FEIS, we contend, analyzed the 4 to 6 stories in corridors.
You say so, and you would say so to the hearing examiner.
Yes.
But the parties might say, hey, you know what, when you look at phase 2, you didn't look at whether or not Seattle Power and Light can provide light poles on the arterials to serve these increased densities. So what if that's their argument, and you say it's fine, and the hearing examiner decides something different? And wants more analysis on something, on an issue like that.
I would say that if the examiner is examining that exact FEIS, there would be a parallel proceeding going on before the Growth Management Hearings Board, and you could have
How is there a parallel proceeding going on the Growth
Because
Management
someone
Board
could-
if it hasn't been adopted yet?
Because it analyzes the comp plan, and so those exact same environmental impacts are going to get,
Growth
are going
Management
to,
Hearings Board doesn't evaluate the FEIS under the legislation. I mean, that's been taken away.
yes, and that underscores why the entire appeal is frankly unlikely that the legislature intended to allow this type of appeal.
Why wouldn't the legislature intend to allow the city to have the best information before it's decided? And then once the city makes that decision, fine, the legislature's taken away any appeals
Because-
of that. Why wouldn't the legislature still allow the city to still have the best information in front of it?
Because the legislature wants to prioritize promoting housing construction, and it does not want to bog down housing legislation in SEPA appeals, which is exactly what has happened
The
here.
legislature could just say, SEPA is done. It's moot.
They could. It is the
But they didn't.
legislature's prerogative.
Right, but they didn't.
They passed this statute, which
I mean, the city still had to go through an environmental review before adopting the
Yes.
1 CL. So it's not gone. The city still has to go
Correct.
through EIS.
and they did.
And you're telling me that there's no process to determine whether the information that was provided to the city can be reviewed?
Correct. That is the legislature's prerogative, and that's what they chose to do.
And the city can't even make the election that it prefers a little more process.
Correct.
Before it acts.
That is the legislature's prerogative, and that's what they chose to do. They created SEPA and the GMA, and they created the appeals process, and then they decided to take those appeal processes away for housing legislation like this.
And I'm going to repeat one more time. They did not take away 4321C-075 that allows the city to do this.
Correct. But they also did not amend 413075 with respect to subsequent appeals in that statute. So that statute, and I'm glad you brought that up, Your Honor, that statute shows that the legislature prioritizes post-decision appeals. They do not prioritize pre-decision appeals like this one, which is what makes the
I mean, that's right, right? The legislature doesn't care if the city has a pre-decision process, because that's not their concern.
it
Their
is
concern is post-decision appeals, and that's what they clearly have taken away.
it is their concern though, because these appeals, as we say in our briefs, are just as disruptive to housing production and capacity and the crisis of housing crisis
Why
as
doesn't the city amend its code to take away the voluntary level of appeal it doesn't have to offer?
you're right that the city can still do that. I would argue, as I did, that there is a provision that expressly cites these. And again, it cites these and says exempts certain council land use actions from administrative or judicial appeals.
I guess my
But
question
this is,
would,
okay, go ahead.
my question would become, why don't they do it in a manner that a judge as dense as me could see?
Look, I will admit, as I said before, that not everything is super clear, but I wouldn't say that it's ambiguous. And I've got 2.5 minutes left here.
Can you address, Godfrey in particular makes the argument that it's not just the phase 2, but there's going to be subsequent decisions that rely on the FEIS that cannot be appealed. I mean, they're arguing that if the city changes say the city changes its critical areas ordinance and relies on this FEIS, that's going to be a subsequent decision that cannot be appealed. Is that the city's position?
I'm not sure if I could answer that hypothetical with that.
I mean, if the FEIS is inadequate to address I'll just pick on critical areas ordinance. The city
Yeah.
decides to change its critical areas
Yes.
ordinance and reduce all buffers to 0, and relies on an EIS that didn't reduce them to 0. Would that be subject to appeal?
No, because I don't
So the
think
city can do anything
I-
it wants because this EIS has been issued, right or wrong, it's issued, so therefore the city can do anything.
I don't think I see your hypothetical. I don't think that would happen. But if it did happen, I think there would be a stronger argument that there is absolutely no connection between this FEIS and the legislation that you posed. So there might be more of a case there, but
I mean, they can't challenge it for not having an SEIS. I mean, where's their challenge?
so and this is where I keep coming back to, the legislature created these appeals and it can take them away. That is their prerogative. And the appellant's entire argument really hinges on one word: adoption of, which this misses the forest for a single tree. They focus on that single word in isolation at the expense of the express purpose that which I laid out, related statutory provisions, and the overall SEPA appeal process, which prioritizes, in general, post-decision appeals and not pre-decision appeals. So it seems inconceivable that the legislature would allow pre-decision appeals to occur, which are basically interlocutory appeals because there hasn't been a final decision yet, but the legislature would bar appeals of final decisions. That doesn't make sense.
Why wouldn't it? Again, I'm going to come back to what we've repeated back and forth a couple times. Why wouldn't the legislature allow the city to have the best information in front of it before it makes a decision?
Because the city still does environmental review. In this case, it did 2 years of review.
But
and
there's
so
no way to know if it's valid.
that is, the legislature has decided to not allow appeals, and that's because they want to promote housing construction so things don't get bogged down, just as the injunction motion would continue to bog this legislation down. Thank you, Your Honors.
Thank you very much.
I think just following up on some of the court's questions, I think that what really comes through when I was looking at this about what did the legislature intend to do. Initially, they enacted 3 separate statutes that have these prohibitions. And at some point, they take those 3 statutes and integrate them into SEPA. And they do that in section 425. They create a new section. They take that. In fact, they modify the ADU one, which just said actions, and put the adoption of ordinances, so on and so on, all together. Now, at that time, certainly, they have right in front of them in SEPA the specific avenue available to take an appeal of an orphan EIS in certain cities if they've adopted that procedure. It's sitting there, and yet they don't do to bring that into the prohibitions or do anything else to knock it out. So, but I think that's just an additional factor that shows what the legislature had in mind. Twice they kind of had the opportunity to think through it again and say, well, oh, wait a minute, maybe this out. Didn't. There was some reference here about some additional parts of the city's code or something that refers to the waiver statutes. I haven't really seen that argued, and it's certainly not the provisions that the examiner relied on.
Well, let me ask you, the last sentence on that section says, environmental documents and council land use actions intended to be exempt from SEPA appeals pursuant to 4321C 495 should so state. Did the EIS here state it could not be appealed to the hearing examiner?
I'm sorry, I lost.
Did the EIS state that it could not be appealed to the hearing examiner?
No.
Did it state it could be
No,
appealed to the hearing
in
examiner?
fact, when the FEI issued and there's the press release, you go pick it up and announces it. It gives you the steps. You have 14 days to file your appeal. So not only do they say you can't take an appeal, they say they can tell you how to do it. And so that's why we have all these showing filing. We had what, six persons, a lot of pro se's, file these petitions. So no. If I may make a quick, again, remark about Mr. Carey. His circumstances where you don't know about the Phase 2 type of things that we're concerned about until well after the comment period for the draft EIS, you should not be foreclosed. When you did comment before EIS on it, from continuing your appeal, just simply recognizing that if something was stated in the draft, it's assumed that you didn't object to it. And with that, Your Honor, thank you.
Thank you.
Counsel for the city says that, quote, adoption of language that refers to the duration of the prohibition of appeals works is in isolation. That is just wrong. The adoption of is not in isolation. It's a core part of the fabric of what we're dealing with. God is not exempt from going up to the growth board under these statutes because almost every element of her appeal deals with fish habitat, loss of trees, impervious surface and its mitigation over time, to what I spoke about, the ongoing future SEPA actions that rely on this EIS. We're dealing with proposed non-project action, a 10-year plan that is citywide in scale and regional in scale. Seattle is the largest area. It emits water with pollution to waters of the state to a large degree, and this process should not be truncated to eliminate the ability to inform the city council about what they are adopting. Please reread the amicus brief. That's the point, that this is a public interest appeal of the ability of the city council know, yes, we support more housing. We support more low-income housing. We support preventing and mitigating displacement. But those do not happen. Have no analysis of the adequacy of those measures either. That's why we have SEPA appeals, to do a check on the work by the department whose task is to promote.
I want to make sure I understand. Godfrey's issues are on fish habitat. So your position is that those can still be appealed to the Growth Management Hearings Board, those issues?
Correct.
Can the SEPA review still be appealed to the Growth Management Hearings Board?
They're one and the same.
I mean, the Growth Management Hearings Board normally can hear the adequacy of the EIS.
Yes, correct. The Growth Board, under the Act, has jurisdiction over associated SEPA applications related to the decision. It's called the One Seattle Plan EIS. It has GMA and SEPA right in the name.
Okay, thank you very much. That